Welcome to the second part of our four-part webinar series dealing with dispute resolution in the construction sector. These webinars examine four different methods of dispute resolution, outlining the background, procedure, and underlying principles of each. We will also discuss the practical applications of these methods to different types of disputes and how each has been adapted as a result of COVID-19. So our webinar today will focus on the use of arbitration in the construction sector. If you would like to ask a question, please do so by using the Ask a Question tab. In order to keep within time, we will be answering as many questions as we can at the end of the presentation, rather than as we go along. If we don't manage to get to your question, or if you are listening to a recording of this webinar, we would be happy to address any queries after the webinar by phone or email. Our contact details are noted on the next slide. So I am Nathaniel Buckingham, an associate specialising in construction and engineering dispute resolution. I am joined today by my colleague Lisa Ambrose, a solicitor in our team. Our team regularly advises on construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience in litigation, arbitration, adjudication and mediation, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. So I will now pass you over to Lisa, who will run through the agenda for today's webinar.
Thanks, Nathaniel. We will begin our presentation today with a brief overview of the history of arbitration before moving on to discuss the introduction of the Arbitration Act and how arbitration is practiced under the auspices of the Act. We will highlight the three key principles which guide arbitration and explain how they are reflected in the current governance structure. We will then discuss how arbitration has responded to the current remote working environment. As with many of our other webinars, we primarily deal with Scots law and more specifically the Scottish Arbitration Act in this session, but touch upon the position in England as well. Much of Scots and English contract law and many of the standard form contracts used for construction projects are common both sides of the border. We advise on both Scottish and English disputes regularly. But before all of that, the first thing that we should cover is what arbitration actually is. So arbitration is a private dispute resolution forum which is often employed as an alternative to court. The parties to the dispute appoint an arbitrator to act as a judge who reaches a decision which is binding on the parties. Alternatively, the parties can also appoint a panel of arbitrators, known collectively as the tribunal. The terms are often used interchangeably. Arbitration is based on the law of contract. The arbitration agreement is what gives the arbitrator jurisdiction to decide on the dispute, and it is by this arbitration agreement that the parties are bound to follow that decision. This is a distinguishing feature of arbitration, which can be seen when we compare it to other forms of dispute resolution. For example, mediation, in which the third party is there to assist the parties in coming to their own decision. Arbitration is an attractive option due to its flexibility. The procedure can be adapted to suit the parties and their dispute. Parties also favour arbitration as it is confidential, which can be beneficial where the dispute is commercially sensitive. An arbitration award is final and binding on the parties and cannot be challenged except on very limited bases. These are a lack of jurisdiction, a breach of natural justice on the part of the tribunal, or appeals on errors of law, if the default rules are applied, which we will discuss later in this webinar.
So historically, arbitration in some form was practiced in Scotland before the public courts were established and has since continued as an alternative to litigation. Until relatively recently, arbitration was conducted under judicial principles derived from cases in the 19th century, which were occasionally supplemented by legislation on specific aspects of procedure. The law was patchwork and difficult to understand, and in the absence of a comprehensive set of rules, too much was left in the hands of the individual parties to the dispute, and this often prevented arbitration from being an effective way of settling any dispute. The arbiter, as they used to be called, also lacked many of the powers which they are now granted. For example, an arbiter had no power to award damages or to order payment of interest on any award. This latter deficiency was especially problematic, as arbitrations could last much longer than they do now, up to 8 or 10 years in some instances. It is clear to see that this framework was considered unfit for the modern commercial environment. Arbitration became so unpopular that in 2005, the Scottish Building Contract Committee removed arbitration as a default method of dispute resolution from its standard form construction contracts.
These days, arbitration is governed by the Arbitration Scotland Act 2010. This provides a modern statutory framework for domestic and international arbitration in Scotland. The Act came into force with effect from the 7th of June 2010, but it is important to note that the Act applies retrospectively to existing arbitration clauses in contracts concluded prior to the date of commencement. The main body of the Act runs to 37 sections and regulates the external aspects of arbitration, so for example, the enforcement of the arbitral award. Schedule 1 contains the Scottish arbitration rules, which are further subdivided into mandatory rules and discretionary or default rules. The default position is that all of the rules apply. However, before the arbitration commences, parties can agree to opt out of the default rules. This allows parties to shape the procedure to suit their dispute. Section 1 codifies 3 key principles which have always guided arbitration and which are reflected in the provisions of the Act. There is a wealth of case law which allows us to predict how these provisions are to be interpreted. The first principle is that the dispute is to be determined fairly and efficiently. The arbitrator is under an express duty to act independently and impartially, and to avoid incurring unnecessary delay and expense. The arbitrator is also bound by a duty of competency, and it is a prerequisite to the discharge of their judicial function that they will adequately inform themselves as to the nature and merits of the subject in dispute. The second principle is that the parties have autonomy to influence the course and procedure of the arbitration. This is reflected in the parties' ability to disapply some of the arbitration rules and thereby influence the way the proceedings are conducted. The third principle follows naturally from the second, and it is the limitation of the court's power to intervene in the arbitration. The Act confers on the courts an intentionally limited power of intervention, which therefore empowers arbitration as the party's chosen method of dispute resolution.
So how does an arbitration begin? Well, a party commences an arbitration by notice to the other party that they intend to submit a dispute to arbitration in accordance with the arbitration agreement between them. This agreement will often set out the procedure by which an arbitrator is to be appointed. This arbitration agreement can be an ad hoc contract of submission. The parties enter into an ad hoc contract of submission where there is an existing dispute between the parties and they agree to submit them to arbitration. However, there is no requirement that the arbitration agreement be a separate standalone agreement. An ancillary arbitration clause which forms part of another contract may also be regarded as an arbitration agreement. The Act recognises arbitration agreements which are concluded orally, but this would be invalid where it relates to certain subjects, for example heritable property, and may also lead to problems with enforcement. We would therefore always strongly advise that arbitration agreements are made in writing. The default rule under the Scottish arbitration rules is that the parties must jointly appoint an arbitrator within 28 days of either party requesting as such. If not, either party may seek the appointment of an arbitrator by an arbitral appointments referee. There are a number of bodies that may act in this capacity, as laid out in the Arbitral Appointments Referee Scotland Order 2010. An arbitrator can be removed by agreement between the parties, and the removal is effected by notifying the arbitrator. The parties can also agree to allow a third party to remove the arbitrator on their behalf. Parties to the dispute can also apply to the court to have the arbitrator removed. There are 3 grounds on which a party can apply for the removal of an arbitrator. An arbitrator may be removed where they are not impartial or independent, where they do not treat parties fairly, or where there is a risk of substantial injustice.
As we have already alluded to, arbitral proceedings are flexible and depend on the default rules that are to be modified or disapplied by the parties. The default position is that the tribunal has a wide range of powers over how the arbitration is to be conducted, as laid out in Part 4 of the Scottish Arbitration Rules. The default rules confer on the tribunal the general power to determine the procedure to be followed in the arbitration, whether there should be a hearing, in person or virtual, whether oral submissions are to be heard, and so on. These also empower the tribunal to decide on the nature of its approach. So, for example, the extent to which it should take the initiative in ascertaining the facts of the law, and whether it should apply the laws of evidence used in legal proceedings or apply other rules of evidence. Another default rule empowers the tribunal to order that documents are to be disclosed. It must be noted that this does not extend to third parties. An arbitrator does not have the power to compel a non-party to disclose documents or to appear at hearing to give evidence. A party must instead apply to the court to obtain such an order. The tribunal has the power to rule on the scope and nature of any witness evidence. Acting under this power, the tribunal may strike out averments as irrelevant, as was ruled by the Outer House in the case Arbitration Application No. 3 of 2011. The reference to that case is on the slide. Where a party fails to attend a hearing or comply with a direction of the tribunal may proceed with the arbitration on the basis of the evidence before it, or it may draw an adverse inference from such non-compliance. This is in accordance with the first principle of the Act, as it punishes unreasonable delay, ensuring that the arbitration is conducted efficiently. The pursuit of efficiency is also evidenced in the tribunal's power to consolidate an arbitration with another, or to hold concurrent hearings. This can be useful where multiple disputes arise out of the same situation, which can be a common occurrence in the construction sector.
As mentioned, the powers of the court in relation to arbitration are limited in accordance with the third principle of the Act. Those powers the court can exercise are limited and intended to support rather than conflict with the arbitration. Under Default Rule 41, the court may determine any points of Scots law arising in the arbitration on application by any party. The pre-statute equivalent of this rule was often abused by parties seeking to delay the trial, and so the rules are drafted to discourage misuse of this procedure. An application under this rule is only valid in 2 circumstances. The first is a circumstance in which parties agree that such an application may be made to the court. The second is where the tribunal allows the application to be made and the court is satisfied that there is good reason why the question should be determined by the court. Parties are, of course, free to decide that the default rule should not apply at all. It may be commercially sensible to refrain from referring the matter to court, for example, where the sums in dispute do not merit the additional expense of court action. The court also has an important role in supporting the arbitration process. The parties can apply to the court to vary any time limit relating to the arbitration. The court may order any person to attend a hearing for the purposes of giving evidence, in line with the usual civil rules. It may also require any person, including a person who is not a party to the arbitration, to disclose documents or other material evidence to the tribunal on the same basis as in civil proceedings.
So turning to awards, Part 6 of the rules confer on the arbitrator the power to make awards of a specified nature. Rule 48 provides that the tribunal has the power to order payment of a sum of money, including a sum in respect of damages. They may also order that interest be paid on any award. This rule addresses two shortcomings of the previous law, which were mentioned earlier. Rule 49 gives the tribunal the power to make an award of a declaratory nature, to find that a legal right either does or does not exist, as the case may be. This rule also confers the power to order a party to do or to refrain from doing something. Finally, acting under this rule, the tribunal may order the rectification of a deed or a document. The parties may decide amongst themselves that the tribunal is to have certain provisional powers, specifically the power to make a provisional award or to make an order to do or to refrain from doing something on an interim basis. The arbitration rules also contain a slip rule. This allows the tribunal to correct clerical, typographical, or other minor errors in the award. The tribunal may also clarify or remove any ambiguity in the award under this rule.
So turning now to expenses, the parties are severally liable for the tribunal's fees and expenses, including the expenses of any clerk or expert appointed by the tribunal. These fees may be charged at a reasonable commercial rate. A default rule allows the tribunal to make an award allocating the party's liability for recoverable arbitration expenses. This includes the arbitrator's fees and expenses, as well as the legal expenses of the other party to the arbitration. In making an award of expenses, the tribunal must have regard to the principle that expenses should follow a decision made in favour of a party, i.e. a success, except where this would be inappropriate in the circumstances. In practice, this means that the question of expenses in arbitration is arguably much more difficult to predict than expenses in a court action. Generally, in Scotland, successful parties can expect to recover around 50 to 60% of their expenses. But in arbitration, expenses are entirely down to the discretion of the arbitrator and subject to a general provision of reasonableness. This means that even if a party wins by a very small margin, they may still be awarded all of their expenses. As a result, parties often have to take a much more cautious approach in arbitration to guard against the risk of having to pay the other side's expenses, which, depending on the length of the arbitration, may be substantial. Parties cannot agree to allocate expenses before the arbitration starts. Any agreement allocating the parties' liability between themselves for any or all of the arbitration expenses has no effect if entered into before the dispute being arbitrated has arisen.
In keeping with the principle of the limited interference by the courts in arbitration, there are only certain circumstances in which a party can apply to the court to review a decision of the tribunal. A party may challenge the decision of the tribunal on the grounds that the tribunal did not have jurisdiction to make that decision. The tribunal has the power to rule on whether it has jurisdiction to decide a dispute, but that power is subject to the review of the court. Another ground for challenging the decision is that there has been a serious irregularity. Serious irregularity includes any irregularity which has caused or will cause substantial injustice to the appellant. For example, an arbitrator not being impartial or independent, or an arbitrator not having treated the parties fairly. The final ground for challenge is that the tribunal erred on a point of law. Unlike the other two grounds of challenge, which are mandatory, this ground can be modified or disapplied by parties in their arbitration agreement. An appeal may only be made by agreement between the parties or with the leave of the court. The court will only grant leave in one of two situations. The first situation is where the point at issue substantially affects parties' rights and the tribunal's decision on the point was obviously wrong. The second situation is where the point is of general importance and the tribunal's decision is open to serious doubt. The Outer House's decision in Arbitration Application No. 1 of 2013 made it clear that there is no crossover between the serious irregularity and appeals on a point of law. Any such application is made to the Outer House of the Court of Session and is heard by a single judge. It can be considered on paper unless the court is satisfied that a hearing is necessary.
So in 2012, the Scottish branch of the Chartered Institute of Arbitrators created the short form arbitration rules. These sit beside those of the Arbitration Act and, while designed for disputes under £25,000, can be adopted really in any dispute with the agreement of both parties. They were intended to create a fast-track route for lower value claims to ensure that cost associated with pursuing a claim stays relative to the value of the claim. Under the rules, an arbitration should be finished within 77 days, as can be seen on the slide. It is worth keeping these in mind should you be involved with a lower value claim under these rules.
The Arbitration Scotland Act 2010 is broadly similar to the statute which governs arbitration in England, which is the Arbitration Act 1996. Both acts share the fundamental principles of fairness and efficiency, party autonomy, and limited court intervention. Concepts such as the consolidation of multiple arbitrations and the slip rule reflect similar provisions in England and in other jurisdictions. Scottish courts have therefore held that cases dealing with arbitrations under the Arbitration Act 1996 are relevant as guidance when interpreting the Arbitration Scotland Act 2010. There are certain provisions of the 2010 Act that can be seen as legislators essentially filling in the blanks of the English model. A good example of this would be the express and detailed provisions on confidentiality, a topic which in England is left to the common law. However, there are some differences in the arbitration legislation north and south of the border. If a challenge is made to court in respect of an arbitration, the courts will keep the parties' names and details of the case anonymous so as to preserve confidentiality. It is possible to persuade the court that the case should not be reported at all. In England, this is a matter of discretion for the court. Finally, to reduce unnecessary court challenges, the Scottish Act limits appeals to the court and from the Court of Session to the Appeal Court or the Inner House. There is no option to appeal to the Supreme Court.
So let's have a quick look at COVID impacts on arbitration. So obviously, due to the current COVID restrictions on mass gatherings, many arbitrations are currently being conducted entirely virtually. I would say that arbitration is much more suited really to being ran remotely than litigation, and this, as well as the decrease in the capacity of the courts during the COVID issues, has led to a surge in popularity of arbitration. It is not uncommon really for arbitrations to run only on the basis of affidavits, productions and written submissions, all of which can be provided remotely. Furthermore, while the prescribed method of commencing arbitration proceedings will depend on the exact wording of the parties' arbitration agreement, it is often the case that the parties are able to commence proceedings electronically. The use of video conferencing has been standard practice for international arbitration proceedings for a number of years now, so there are certainly some arbitrators with experience in these matters. Indeed, the power of the tribunal to modify procedure means that they are often able to overcome the additional barriers that are posed by remote hearings and the coronavirus circumstances. For example, it would be open to a tribunal to set procedures as to whether oaths can be administered remotely under applicable laws and to ensure that witnesses are alone in their locations. Tribunals can also rule to ensure that participants who temporarily lose an adequate internet connection can connect to the proceedings by alternate means to avoid allegations of ex-parte communications where an internet connection fails. However, remote arbitrations can still have their problems. Virtual hearings are often less efficient, really, than court or in-person proceedings, which can put pressure on the parties if the time for the hearings are not extended to reflect this. Such inefficiencies can be of particular importance in disputes involving, say, a large number of productions, as construction disputes often do. There are a number of extra difficulties that can be posed by conducting a virtual hearing, from unreliable internet connections to server crashes or even family members running riot in the background. No doubt we've all experienced a number of these issues ourselves over the last period. And electronic document production can also pose its own unique headache, and the logistics involved in setting up the technology for all parties adds another set of tasks that simply do not exist in in-person hearings. These should be borne in mind, and borne in mind that it will take time to prepare over and above all the other preparations that are required should the tribunal decide that there should be a hearing and that it is to be a virtual one.
We have now come to the end of this webinar, which we hope has been useful to you, and we still have a few minutes to answer any questions. If you haven't already done so, please type your questions into the chat box now. While you're doing that, I would just like to remind you that the next webinar in this series will be available on Tuesday, the 8th of December 2020, and will cover adjudication in the construction sector. If you would like to sign up for this webinar, please visit the events section of our website. You can listen live or can register to be sent a recording of the webinar and to listen to that at your leisure.
Thanks, Lisa. Let's have a look at the questions. Okay, so there's a question about the uptake of Scottish arbitrations since the 2010 rules. That's a very good question. So it's been about a decade since the Scottish arbitration rules came into force, and the question is whether there's been an increase in the uptake. And I think our answer to that would be yes, there has been. It's increasing. As we described at the beginning of the webinar, there were historical problems with arbitrations that put a lot of people off of them. But I think since the 2010 rules have come into effect, people have become gradually much more comfortable with Scottish arbitration. So we're not starting from a particularly high base. There are not many arbitrations before 2010. And obviously at that time the Court of Session was pretty well known and trusted. But I think there has been an increase as the comfort of the rules and the arbitration process in Scotland has increased. And as we mentioned, certainly in the last year, with the coronavirus circumstances, that really has made people think about how they tackle their disputes and whether the public courts are the best place, or whether really, I suppose, making their own arrangements through a private arbitration can be better. So I think they've probably increased even more over the last 9 months than before. So yeah, certainly the uptake is increasing. Let's have a look. I think we've got time for one more question. So this is a good one, actually, a fairly classic question, which is how would you decide between, for example, the Court of Session or litigation versus arbitration? There's obviously pros and cons to both. I think the first part of that answer is obviously, first of all, go and look at your contract, because it's very usual that your contract will tell you, or it will have already been decided, what your dispute resolution route is. So you might have no choice whether to go to court or whether to arbitrate. In terms of if you either do have a choice, or if you're at the stage of, I suppose, agreeing your dispute resolution process in a contract, there's certainly pros and cons to both, and we do find that it depends on the parties, and people can have particular preferences. certainly the main pros for arbitration that comes out in our discussions with clients is the privacy and confidentiality aspects. Having a dispute resolved out of the public gaze has a lot of attraction for commercial clients. And I suppose also sometimes speed, particularly if it's under quite good rules, then arbitrations can be quicker, and there's certainly more control over the speed than perhaps a slight vagueness of timescales in the Court of Session, where, for example, the timescales might really depend on how busy the court is at any particular point. However, some people do prefer the courts. Even commercial clients, and certainly others, can just look to have their day in court. They may actually appreciate the public side of court and perhaps might have more trust in, I suppose, public justices and more confidence in that process than a private arbitration practice. So certainly those people who have less experience of arbitration might be a little bit more skeptical about it. But both work fine though in the end, really, and our experience is that both tend to, in the round, I suppose, tend to deliver justice. So it probably will depend on a client's or your particular circumstances and preferences. I think that's all I would say on that. So I think that's probably all the time we have. If there's any other, just looking at the questions, if there are any others that we've not answered, we'll come back after the webinar and answer them. We do hope that you've enjoyed this webinar, which has been recorded and will be available on our website shortly. We will also be circulating details of the recording to participants after the webinar. Now our contact details are on screen as well, so if you'd like to get in touch with either of us, please do so. All that remains to be said is thank you for listening, and we look forward to speaking to you again in our next webinar on the 8th of December. Thank you.